Great news. We have two great news to share with you guys. We have an I-130 petition approved. It took too long because it was so complex. In this video, we'll talk about it. Then we have an expedited request approved. This is for a VAWA petitioner, okay, self-petition. We're going to talk about those two cases. My name is Bijou Ngwanda. I'm an immigration lawyer based here in DC. I work with individuals across the country and around the world because we're dealing with complex U.S. immigration law cases. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing, and please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and share, like. Don't forget to comment below. Also follow me on Instagram. We already have at least 227 followers. We need to get to 1,000. Come on, folks. You can do it. Link in the description box below. If you need a consultation, my phone number is 202-751-2180. You can also email me, bijou.ngwandaesq@gmail.com. Consultation link is right here in the description box. You can schedule your own consultation on your own time. Please do not send me email with questions because I'm not going to answer them. Just either you schedule a consultation or you post your question here, right here on YouTube or on my private Facebook group. Either way it works, right? So let's get right into the subject. I-130 petition based on marriage, approved 1.5 years later. Filing date June 22, 2021. Approval notice, we got it on January 3rd, 2023. 1 year and 6 months, okay? So why? Because it was complex. So what's going on here is this, right? Clients into the United States around 2002 or 3 with a B1/B2 visa. At the time client went to the consulate interview, client misrepresented facts. We've talked about it. Lying to the officer, like lying to the U.S. official, it's pretty much not a way to go. It's going to cost you time. It's going to cost you money in attorney's fees. It's going to cost you money in USCIS fees, okay? Just don't do it. Just state the facts the way they are. So clients just pretty much lie to the misrepresent facts, let's put it that way. So misrepresent facts to the U.S. officer, okay, at the consulate. So U.S. official, pretty much the consulate, they asked him, are you married? Client said, yes, I am married, but in fact, client was not married. Client just stated that because he wanted some credibility, to boost his own credibility so that he can get the visa to get here, which worked. Got a visa, get to the U.S. Well, now this is the problem, right? So now client now gets into a real marriage, right? So, well, when you go to a real marriage, that's when you go to the interview. That's when they start verifying all the facts. The manner by which you enter the U.S. matters, right? The things you said matter. That's when you have to really go back and find out what you said and how you can repair it, okay? So client goes to the interview, then they filed that petition in 2010, okay? But prior to going to that marriage interview in 2000, I believe in 2011, what happened was he actually got married before then, but unfortunately that marriage ended in divorce, and he was sent in removal proceedings. So now we're talking about a second marriage with a U.S. citizen, but because he was in removal proceedings, the former lawyer really did what he was supposed to do, administratively close that case, okay? Put it on pause so that he can follow his I-130, follow up on I-130 with USCIS and eventually green card. So that's what happened. So now they go to the interview, 2010. Well, that's when they pull your file and they ask you several questions. Well, at that point, the client was supposed to just tell the truth. They tell the truth, then they ask him, well, now you have to provide proof that you were free to marry, because now we have to question your credibility, because you said that you were not married, but you pretty much lied to the U.S. official, misrepresented facts. Now you're saying that, well, you just said it because you wanted to boost your own credibility. So, well, now we have doubt on whether or not you are free to marry. So eventually he had to provide a lot of proof, but still didn't work out. He went on appeal, but unfortunately it didn't work out. The case got denied back in 2018, but it took too long, right? Remember, from 2010 to 2018, right? Just to finally get a denial. Well, first of all, you waste a lot of time in between. So then client comes to me in 2021. So when I look at the case, where I just said, you know what, we need to just file a new I-130. But this time around, we're gonna brief them, okay? We're gonna brief them of what is actually going on. So, because if you know how to write those briefs, okay, and state the laws, and state the facts, and defend your facts, and really provide an argument. So at that point, when the USCIS officer read your file, so they have an idea of what's going on. Eventually, you have evidence to support whatever you're saying, so that there's no more question. That's exactly what happened when the client came to me. So I had to write a brief. It was too complex. I had to go through the entire file to know the history of his whatever petitions he was filing, the history of the court, what's going on with his case at the court. Then we wrote a brief, 5 pages brief. So straightforward, with arguments, with facts and evidence. We sent that to USCIS. Just I-130 petition alone, because I knew that the client is in removal. We cannot adjust status with USCIS. Then client was having extreme hardship when it comes to financial, so he couldn't work without, because he didn't have a work permit, just struggling here and there. So we said, yeah, you know what, in order for you to get a work permit, we have to go back to USCIS and file with the Green Court. We know that's what's going to happen is, well, if they're not convinced that they don't have jurisdiction, they're not going to give you Green Court. Eventually, they're going to give you the work permit, because that's how it works, right? Green Court pending, I-130 pending, I-765 pending, then you're entitled to a Green Court, to a work permit based on the prima facie of the case, right? So a year later, he gets his work permit. For those who actually ask how long it takes to get work permit under marriage, well, at least just wait for 1 full year, okay? Give it at least 1 full year. Within that 1 full year, you should get your work permit. Exactly what happened, he gets the work permit. So now the question becomes, when are they going to approve that I-130? When are they going to call him for this Green Court interview? Well, after they got to his case, they read it, and they approve the case. Remember that when you file for I-130 and I-485 together, the timeline processing time is the Green Court processing time, because now it's concurrent, right? So they go with Green Court processing time. So while they look at the case, they approve the I-130, but because they don't have jurisdiction, which we kind of knew, but we went with them with that anyway, because we really wanted to get that work permit out of the way. We didn't want to go with the case from the courts, get the work permit under the case for the court, because remember that case was closed because the marriage ended in divorce, right? So there was no entitlement for a work permit under the court case. So we have to go with this new case to get a work permit. That's why we filed I-485 with USCIS. So we got everything we wanted accomplished, okay? So now we have to go back to court and recalendar and terminate, recalendar and terminate removal proceedings so that USCIS will have jurisdiction, then we'll go with that order of removal being terminated by the judge to USCIS, and USCIS will just pick up from where they left off, which he has at least 6 months left, because remember, it takes at least 2 years minimum, at least, right, to adjudicate that green card under marriage. So we're still within that time frame as far as green card is concerned. But the moral of the story is this: misrepresentation of facts, okay, lying to U.S. official, it's big nose, because it's gonna cost you really. Sometimes you really have to apply with a waiver, but in our case, because we so good in writing our briefs, we just overlooked that, and the fact that he admitted to those allegations made it a little bit much easier to not file with a waiver. So we just had to go with the brief and laws and argument, and they granted the I-130 without interview, okay, because they were so clear at that point as far as our job is concerned. So we're so satisfied about the way we work when it comes to defending our clients. But at the same time, we just have to advise some people to learn from the story, because it's going to take you time. It's going to take you money, USCIS fees, attorney's fees. Mind you, this client has changed at least 3 lawyers, right? Finally got to us, and we're able to deliver. But mind you, since 2002, he got here in the US, right? Or 2003, but just got his approval of I-130 in 2023. You see the lapse of time? But mind you, he applied for that early in 2010 with the second marriage. So it's like 10 years later, right? So, or 12 years later, just to get the I-130 petition approved. Why? Because of misrepresentation of facts. It just takes you and if you have a lawyer that's not really qualified in writing those briefs and putting forward good argument, it's just gonna waste your time and money. Representation matters. And qualifying representation matters as well, right? So that's what we're talking about. We are talking about this is great news, and we have to go back to court. Really, that's an easy task, because now it's just about recalendering and terminating removal proceedings and going back to USCIS. If we look at the time frame, again, it's still going to take the same time frame, the 2 years period of time, because we apply in June 22nd, 2021, and then the green card application was filed later in sometime in September, right, of 2021. So let's move on to the second case. The second case is about expedited request for a VAWA petitioner. Remember, we've talked about those expedited requests. It's case-by-case basis. I don't really do it that often unless I have something really strong. It's like shocking that USCIS will have no choice but to actually expedite the request. That was the case for our client, but unfortunately, it's a very unfortunate situation because the child is sick, seriously sick, but at least we're gonna get this VAWA petition decision so that she can get the green card and receive government help so that her child can go through surgery. And we wish her well in the process. If you need a consultation with me, please, again, 202-751-2180. Email bijou.ngwanda@gmail.com. Consultation fees apply. We're working on complex immigration law cases. As a matter of fact, we had one, consultation, right, which took us pretty much 1 hour and 20 minutes because the case was so complex. And we had to advise the client, look, you cannot do this on your own. You've been doing it on your own for very long and you're just turning around with no solution. It's time for you to hire a qualifying attorney. And if you do not have one, again, you can contact us. We'll be happy to help you. We want you to have a solution this year. This is the year where we want solution. We want to fight unreasonable delays with expedited requests or lawsuits if we can. We want to represent you and advocate for you beyond just representation. That's what we do too. We get, if we can, especially for people who are here, we can get congressmen involved too as far as expediting cases. We can reach out to ombudsman office, and the last resort, of course, is lawsuit to federal court, really to avoid those unreasonable delays, okay? Especially for clients like mine, a child seriously sick, we had to find a solution. That's what we're here for, okay? That's the job we do, and we take too much pride in doing it. And we're so happy when we accomplish something like this, okay? So this is it for today, my friend. Go ahead and share, like. Don't forget to comment below. Please don't forget to follow me on Instagram. That's almost like a shame. We only have 227. Come on. We have like 11,000 subscribers. Come on, you can do it. Just follow me on Instagram. We're going to talk more on employment base, give you tips, and answer your questions if you post them if you comment on any post, okay? Don't be sending me messages. Just comment. Comment here, comment there. We will answer you. Unless you need a consultation, then you schedule it and pay the consultation fees, okay? Until next time, bye-bye.